Hi AI class, it's Professor Opterbeck, and as promised, here's a short video giving an overview of the EU AI Act. And as I've already mentioned to you, this is going to be one of our main texts for this class. Not because it's perfect, but because it really is the only comprehensive existing AI law at any national level anywhere right now. And in many ways, it resembles the EU GDPR in particular in being a first mover. So the GDPR and privacy was really the first mover of a law for privacy, and the AI Act is really a first mover in the law for AI. And in structure, in many ways, it's similar to GDPR. So you'll see that the AI Act outright prohibits some AI practices, a kind of relatively broad but relatively narrow set of practices, and we'll talk about what those are in a minute. So we have some things that are prohibited, but really the heart of it is a risk management or risk-based kind of set of principles and rules. And we see the same thing in the GDPR. So most of it, or a large part of it, is not really banning things outright, but it's saying, setting aside the pieces that are banned, how are we going to manage the risks of the kind of things that are not outright banned? And GDPR does a very similar thing concerning privacy. Now, you'll see that the EU AI Act breaks these areas that are risk-based, not just outright banned, into two categories. So one is high-risk AI systems, and we'll talk in a moment, give a highlight in a moment of what those are. And the others are general purpose AI models, or GPAI. And as you might imagine, the obligations, the risk management obligations for high risk AI are more extensive than they are for GPAI. And so we'll look at kind of where that divide is and what those different obligations look like. The obligations within the statute are not only to the producer or the manufacturer of the AI system, but include the provider, the person who's creating it and putting the system or the model out there, and then deployers, people who are using that system or model in a commercial setting. Again, this is somewhat analogous to GDPR. GDPR puts obligations on data controllers, the person who's collecting the data, and then data processors, the person or entity who's actually doing something with that data. And of course, a controller and processor can be the same entity. Similarly, under the AI Act, a provider and deployer can be the same entity, but just note that it's really regulation throughout the chain of distribution. The AI Act applies to any AI used in the EU and relating to EU citizens, and the same thing is true of the GDPR. So the GDPR has a kind of extraterritorial effect. U.S. companies really had to scramble to get ready for GDPR when it was coming online, because many U.S. companies have EU data subjects who they're doing business with. And similarly, if you're developing or deploying, providing or deploying an AI system, if there are EU subjects who are going to be affected by it, you're going to, at least theoretically, need to comply with the EU AI Act. It will cover you. Now, that extraterritorial question is an interesting one. It's an interesting one in an international law sense. It's an interesting one as a practical matter. If the EU is actually going to be able to enforce and collect fines against an entity like a U.S. company that's not based in the EU. But of course, there are plenty of companies that are based both in the EU and the U.S. You think of a really big technology company like Google, a global company. It's certainly enforceable there. Like the GDPR, the EU AI Act will establish EU-wide and national level AI authorities. So the idea here is that there's some national regulatory entity that is setting standards, that's developing more specific content in terms of what system is a high-risk system or a general purpose system, or what kinds of risk management practices really are effective and what aren't, and coordinating. And then there are national level authorities. So each member state of the EU, of course, is a sovereign country bound together by the treaty mechanisms that create the EU. So the AI law will require each national state to have its own enforcement authority. And again, this is same thing as the GDPR. There is a European Data Protection Board, and then there are state level data protection offices, DPOs. Now, something that makes that dynamic interesting, it's roughly analogous to U.S. federalism, in that there are individual states and kind of a central authority. But in this European model, the central state is not really a state, it's just a treaty body, and it doesn't have the quite the same extent as the U.S. federal government. The national level authorities have, of course, a lot of autonomy. But when you have a system like this, where you're trying to coordinate all these national level authorities, it gets interesting. It's been interesting in privacy because we see that different data protection offices in different member states will pursue different activities, have different priorities. Some are more aggressive, some are less aggressive, things like that. And we'll likely see similar things with AI, and we'll be looking at, during the semester, a document that's kind of talking about the initial plans of some of the different states. The AI Act is enforceable through fines, through the national level and EU level enforcement authorities. There is no express private right of action under the AI Act, and that's an interesting thing that we will discuss throughout the semester. Is whether regulatory models like this should have private rights of action, and/or whether private law, torts, contracts, and so on, is effective to allow private rights of action. Observers are not entirely in agreement and not entirely clear on whether, even though the Act lacks a specific individual right of action, whether in fact in different member states somebody might be able to bring a cause of action using the AI Act as a standard. And in fact, we will be looking at a proposed EU product liability directive, or I should say a change to the existing EU EU-wide product liability laws that would embed unique product liability principles for AI, and would in fact refer to the AI Act as a set of standards that would then filter into individual cases. So you see here that the Act has now entered into force as of August 1st, 2024, and you can see that there's sort of a rolling timeline for when entities are expected to be fully compliant. So in other words, it's not going to be enforced just yet. There's a period, and this also was the case with GDPR, for entities to come into compliance. So the prohibited practices will be first to cut out GPAI rules, which are, as we said, a little bit easier to meet, and then the high-risk rules, and then some of the other rules. We're going to dig into all these specifics throughout the semester, but just realize that it's in force now, and right now the immediate compliance obligation, if you have a product that might be coming to market, is to try and decide whether it falls into any of those prohibited categories or not, and then to start thinking about general models and products that might be high risk. By the way, if you don't know about EU law and lawmaking practices, you should know at least one basic distinction, and I'm going to try and write it with my mouse here. But the distinction is between a regulation and a directive. So in EU law at the EU level, these are the two basic kinds of laws that can be enacted. What a directive does is it says, here's a floor, here are some basic minimum standards. And all the member states enact their own laws that have to at least meet that floor. They could go beyond that floor. There's often room for interpretation, and so it's allowing for some flexibility, almost like we think of states as laboratories. Not quite like that. It's not the same kind of federal system, but it allows some flexibility. And that has advantages and disadvantages. A regulation, on the other hand, says this is the rule throughout the EU. The member states do not have authority or discretion to enact their own laws that sort of tweak what the regulation does in the way that they would with a directive. So the GDPR is a regulation, the AI Act is a regulation. The national level piece, the flexible piece, is going to be in how these local authorities actually administer and implement the law. So a few of the things I had you read for this week were some of the background recitals, as I mentioned in my note to you about this reading. You know, the EU law and both case law and statutory law seems to love these long, ponderous recitals. In a way, it's useful because it gives you a framing for the whole thing, but it's, as an American lawyer, it can be a little bit difficult it's almost like plowing through reams of legislative history or something before you get to the meat of it. So, but some of these things are useful, and I just want you to note in this kind of the typical language about the risks and benefits of AI. One of the ways that the EU is thinking about when it's talking about AI, and you see this in the recital and in this definition in the actual article, is this idea that it can infer. So it's not an AI system in this view is not simply applying a rote set of rules, but it's got some general conditions and it's making inferences from those conditions. It's an interesting way to put it when as we dig into, as you hopefully this week in some of the videos we've been looking at, as we dig into it some more. I'm not sure that inference is really the right way to think about it. Inference is a process of reasoning, and what AI systems, machine learning systems that are important now are really doing is just giving statistical predictions. What word would come after this word given the words that have gone before. It's not really an inference, I would say, but that's I think what they mean. So here's in Article 3 is the actual EU definition, and there's some other pieces of it in the Act. By the way, the articles, these are the actual text of the law. So the recitals are not the text of the law, but they give background that help you interpret what the law is. Another part of Article 3 giving that definition of GPAI. So notice, generally AI, a system that infers. GPAI, what they're really talking about is models that have been trained on a large amount of data. So general purpose models, like ChatGPT is a large language model, and it can be put to a lot of different uses. It can be used in a chatbot. It can be used to answer search queries. It can be used to write your discussion board post, which you shouldn't use it for. Right, but that's a general purpose model. So here are the prohibited practices in Article 5. Now, I'm not going to take time to read through all of them, and all I'm doing here in these bullets is kind of roughly summarizing. You really need to read them carefully to get all of the nuance, and we will go through all of these throughout the semester in different ways. But you can see generally, right, certain kinds of deceptive manipulation, exploiting certain characteristics of what we in the U.S. would call a protected class, social scoring for unfavorable treatment that is, disproportionate. So we can think of something like China's social credit system, which we'll talk about a little bit later in the semester. Certain kinds of criminal profiling, not all criminal profiling. So there is a pretty significant exception which will relate to something akin to a search warrant, right? Certain kinds of facial recognition, untargeted scraping, not scarping, of facial images from the internet or CCTV footage, so broad, general kind of scraping. Certain kinds of inferring of emotions, particularly in the workplace, or in educational space. And we'll talk about some examples of this during the semester. There are AI systems that can put in your webcam, like mine here, right, while you're at work, and that will be on, and that could actually, through your body language and your facial expression, infer whether you're actually actively paying attention to your work or scrolling through the web, or taking a nap, or just not paying attention, or whatever, right? So that's a category. Certain kinds of biometric identification. So this one is relating to membership in certain protected classes. That could be based on race, it could be based on sexual orientation, things like that. And then biometric identification by law enforcement in certain public places. So one thing to notice about these prohibited practices, it's really a mixture of things that we might consider, that in the US we might consider concerns about the civil claims or about regulation of business between individuals, and things that we might think of as civil rights concerns relating to the individual and the government. So we tend to think, or I tend to think, when I think about the structure of law in the U.S., we've got this vertical dimension of the citizen and the state, and then we've got this horizontal dimension of citizens to each other. And a corporation isn't really a citizen, but right, it's a fictive legal person, right? So our basic civil rights go between the state and the citizen, and we tend to deal with those through constitutional provisions like the Bill of Rights and case law relating to that, and then statutes, usually criminal statutes, that relate to things like wiretapping. So this really puts a couple of those pieces together, I think, in a sort of interesting way. And of course, there's other EU law that would relate to things like search and seizure that's kind of analogous to U.S. Fourth Amendment law. So how do we define high-risk AI? We've looked already at the kind of general purpose system. There's a first section that has to do with AI that involves a certain kind of safety component that's used for certain safety pieces. So take a look at that. But the key categories that we're going to be thinking about are in this annex to the statute. And you can see some of these categories overlap with some of the prohibited acts and other things we've been looking at. So certain biometrics might be prohibited, others are going to be allowed, of course, a facial scan or a fingerprint to open your bank account or your phone, but it's going to be considered high risk, right? Critical infrastructure, education, training, employment rights. So notice education, employment are considered important categories. Some public services, law enforcement again, and then other things that are considered related to human rights, migration and asylum. And then other things, again, that we would think of in the U.S. as kind of government due process sorts of things, administration of justice. You'll notice when you look at these definitions that these categories can be expanded, and it's anticipated that the role of the national and the EU-wide AI authorities will be in looking at and potentially expanding those. So for the high-risk AI systems, as we've said, we have a risk management framework. And we'll talk about these in different contexts throughout the semester, but just take a look at them. And, whenever you're thinking risk management, we're not likely to ever eliminate all risk. In fact, the very word management suggests that the goal is not to eliminate risk when we're doing risk management. We want to reduce risk. But we're always looking at costs and benefits. We're always looking at risks and benefits. And so it's sort of like a duty of care kind of determination that has to be made. And really the key thing in a risk management system that's not establishing a framework for tort liability, what it's establishing is the process that the entity has to go through. So documenting and going through a process of looking at risks and benefits and then justifying why the benefit of this system that is high risk outweighs its risks. And there are requirements on training, validation, and testing of the training data, a requirement for human oversight, requirements about security and accuracy. Notice how all of these requirements can sort of map onto the AI ethics frameworks that we're looking at this week and that I talked about in the other video that I posted. So the GPAI requirements, finally, you can see are not as burdensome, I guess I would say, as comprehensive as the risk management process for a high-risk system. Right? For a GPAI system, you do have a transparency obligation, and that's going to apply to a high-risk system too, by the way. So you've got to give notice if a person's interacting with an AI system. If you're producing output that's done with AI, there's certain kinds of marking and disclosure type requirements. And really the heart of it, I think, is these two things for GPAI. You do have to do a kind of risk assessment, but it's a different kind of risk assessment, and you're really kind of assessing whether it's likely to be a high impact system. If it's going to be a high impact system, you have other requirements, and you fundamentally, I think what the EU is trying to do is make you show that it is not actually a high risk system. But if you do your risk assessment and then you determine that it is a high risk system, you might have other obligations that apply. This again is pretty similar, well, analogous, I would say, to GDPR, because GDPR in certain circumstances has a requirement of doing a data privacy assessment, a DPA. And that is now kind of a standard part of any comprehensive privacy law, including in the US states. So, kind of step one, you might say, well, I'm not triggering all these other privacy obligations, but I'm doing a DPA to document that. And then if my DPA shows that, in fact, maybe I do trigger some of these higher things. And we'll talk a little bit during the semester about kind of the art of risk assessment and doing these kind of assessments, including as a lawyer, because you have to be sort of accurate and fair in your assessment, but there's a balance and an art to when you're making a judgment that you've actually crossed a threshold that requires a higher regulatory obligation, and when you haven't, and if you make the judgment that you haven't, and the regulator in fact decides that you have later on, you want to make sure you've documented why that you think you haven't, and that's accurate. And then keeping certain documentation on training data, issues about copyright. We'll talk about. I've done a lot of work on this. We'll talk about some of that later in the semester. And there's different provisions about developing industry-wide codes of practice or certification regimes that can be developed by third parties and approved by the regulatory authorities, that if you're complying with those those systems, then you're considered to be in compliance with the Act. And we, again, see that paradigm in privacy with having the ability to have certification mechanisms for certain kinds of practices. So again, really quick, really brief overview, but I hope if you step back a little, you get a feel in between all of that long, obtuse language, European regulatory language. It's really a fairly straightforward framework. Keep certain practices out, define certain practices as high risk and subject them to a more extensive risk assessment, define some other things as kind of general models and put them in a somewhat lower risk assessment, have a national authority or a union-wide authority overseeing the whole thing, and national authorities enforcing at the local level. So good. Look forward to seeing you online and continuing our discussion in Unit 2 starting next week.